This past year, we've all been on a huge journey. A little over a year ago, we all emptied out our offices and parked ourselves at home for what we may have felt would be just a few weeks until we would all be back again. It was an emergency situation. No real planning took place. Very few of us made or asked to make formal working from home requests. There were no formal variations to our contracts of employment. Even if there had been formal WFH requests, they would have been in the context of everyone being at home. That is not the same as a situation when some are at work and others are at home. But now it seems clear the end is in sight post 21st of June. Pronouncements by the Prime Minister reported in the press yesterday have underlined that expectation. What is also clear is that the chances that we will all return to the situation we left in March 2020 are very small. So we have to live and work in the new environment. Few in the white-collar and professional services world especially believe hybrid working will not be on offer, if not by ourselves, then by our competitors. There have been many surveys in recent weeks looking into employers' intentions in this respect. The IOD survey, for example, published at the end of last month, found that over 60% of the 600 businesses they surveyed plan to adopt hybrid working after lockdown. More particularly, 63% intended to shift to 1 to 4 days remote working a week, and 10% were looking to have their workforce work from home entirely. With the invitation to this webinar, we also asked you to indicate whether you are considering introducing hybrid working once we physically return to the workplace. Although for obvious reasons you may be a self-selecting group, it is worth recording that some 98% of the 150 or so who accepted the invitation all said they were intending to introduce such a policy. What is also now becoming clear is that salaries and the traditional employee benefits, including coffee stations, soup stations, gyms, yoga classes, ping pong tables and the like, are just not going to cut it anymore. Right at the top of the employee and prospective employees' wish list will be the offer of hybrid working, by which we mean a mix between either working in the office or at home or possibly at some other external workspace. If you're not going to be able to offer that facility, your business will inevitably suffer the consequences. So today's webinar is to discuss the implementation of a hybrid working policy. In order to do so, we'll be looking at this issue broadly in 3 parts. Part 1, how to manage your UK-based employees working from home here in the UK and their physical return to their place of work, the most common scenario. Part 2 will be how to manage your UK-based employees who are working or who want to work overseas. And part 3 are issues with hiring employees and freelancers who are based overseas. We've a lot to get through, and there's much to consider. You've kindly submitted a huge number of very good questions in advance of this webinar, and we've tried to incorporate answers into our presentations. However, if we do not have time to take further questions at the end, we will be very keen to continue our discussion. You'll be invited to speak with us afterwards to clarify anything you're unsure about or would like us to talk about. You could do so in the chat or by way of separate email or call to any one of the speakers. But perhaps the easiest way to communicate with us will be to use the QR code which Melanie, our events coordinator, will put up on the screen afterwards. And when you put your camera to the code, it will then open up an email which will go straight to a dedicated email address at Kingsley Napley and will be replying to you. So we're now going to begin with Natasha Foreman, a senior associate in our employment department, who'll be focusing on the important health and safety requirements that you're going to need to consider.
Thank you, Richard. So how can you effectively ensure health and safety compliance in a hybrid workplace? It's a big question. So employers will need to be mindful of their health and safety obligations to both in-office and home-based staff. For in-office staff, the main focus will be on how to implement a safe return to the workplace. And for home-based staff, employers are likely to face new challenges that they've already been facing, including ensuring that working patterns are not detrimental to health or risk employees suffering burnout. They'll also need to ensure that employees have safe equipment and a suitable workspace. So there are a number of employer duties in this area. Every employer has a duty to take reasonable care of the health and safety of their employees, and this duty arises both under common law and under the Health and Safety at Work Act. It's also an implied term of employment contracts, and employers will need to provide a reasonably suitable working environment for the performance of duties. They must also provide and monitor working environment which is reasonably suitable for the performance of employees' contractual duties, and employers must conduct a suitable and sufficient risk assessment of all of the work activities carried out by their employees, including home workers, in order to identify hazards and assess the degree of risk. They must also abide by the implied duty of trust and confidence, and they're required to do everything reasonably practicable to manage health and safety risks. And if challenged, the onus is on them to demonstrate that they did so. So while the pandemic continues, we now know that common features of the pre-pandemic office pose obvious risks, such as packed lifts, shared workspaces, communal areas, and hot desking. So the question is, how do you bring employees back safely, bearing in mind all of the duties outlined? So the best way to demonstrate compliance with health and safety obligations is usually to follow government and industry-led guidance wherever possible. Current government and health and safety executive guidance focuses on the responsibility of employers to take steps to ensure that the workplace is COVID secure. Employers should take measures that include undertaking a risk assessment and sharing the results with their workforce. And the HSC has produced a risk assessment template to assist employers undertaking these assessments. Following the assessment, introduce any necessary health and safety policies and provide training on them to ensure compliance. If anyone becomes unwell with COVID symptoms, and we're now more familiar with those, they should be sent home and arranged to have a test. So policies that you can introduce might include social distancing, flexible working and staggered shifts, and that can include allowing for different start and finish times in order to avoid busy trains and tubes. Commuting to and from the office can be seen as an extension of the workplace. Also ensure frequent cleaning, adequate ventilation, providing hand hygiene facilities, and where using hot desks can't be avoided, cleaning workstations and shared equipment between occupants. Employers should also monitor the effectiveness of the measures they put in place and keep their assessment under regular review. Employers should also ensure that they consult with employees on plans to return and on any health and safety measures to be put in place, with consideration being given to those individuals with higher risk. So we suggest keeping lines of communication open in order to address any concerns quickly and avoid unnecessary issues escalating as well as potential claims. So it's not yet known how long protection from vaccination will last, sadly, or whether it will be effective against the new variants. And there's some obviously frightening information that's coming out at the moment about those. And it's likely that employers will need to manage employees' concerns about returning and being in the workplace on an ongoing basis for the foreseeable future. So while employees have further protections and rights that I'll come to, it's also worth remembering some of their obligations that come into play. So every employee has the duty to comply with the reasonable and lawful instructions of their employer. They must comply with the terms of their employment contract, and they must take care for the health and safety of anyone who might be affected by their acts or omissions while at work, as well as to cooperate with their employer so far as is necessary in order to ensure compliance with statutory duties or requirements relating to health and safety. There are a number of claims that can arise in this area that employees and some workers can bring as well. So where an employee or a worker raises concerns around health and safety, claims could arise such as unfair constructive dismissal for employees, detriment and dismissal claims which are covered by the health and safety provisions of the Employment Rights Act, and from whistleblowing detriment and dismissal claims covered under whistleblowing legislation. Workers are also protected from detrimental treatment. Under sections 44 and 100 of the Employment Rights Act, an employee may be protected from suffering detrimental treatment or being dismissed where automatic unfair dismissal applies as well as uncapped damages, where there are circumstances of danger which they reasonably believed was serious and imminent, as a result of which they took appropriate steps to protect themselves and others. Now, whether or not risk of infection could constitute serious and imminent danger, and whether or not refusal to go into work or leave the office could amount to appropriate steps to protect oneself or others, is a question which we need to be considered on a case-by-case basis. It is worth noting that the government has already described the pandemic as a serious and imminent threat to public health and safety. So the concept of danger has been interpreted broadly in case law, and it could include the risk of contracting COVID from an infected colleague, patient, or client. So the question for the tribunal will be whether the employee reasonably believed that attending work could put them in danger. This highlights the importance of effective communication with staff in terms of the measures taken to minimise the risk in returning to the office. Much would also depend on the current state of the pandemic, and the serious and imminent danger test may be less likely to be met where the level of cases has dropped significantly. So it's also worth touching on whistleblower protection, because even if it's not reasonable to assert that there was a serious and imminent danger, it is possible that the individual could be covered by whistleblower protection. And for a whistleblowing disclosure of information to be protected, the whistleblower must have a reasonable belief that the information tends to show one of the relevant failures in the act, such as danger to health and safety or a breach of legal obligation. They must also have a reasonable belief that the disclosure is in the public interest, although this is a low threshold test, and most health and safety concerns are likely to qualify. However, such disclosures may not necessarily justify refusal to attend work, and the basis of any disciplinary action would need to be carefully analysed. We would suggest getting legal advice at the outset, as these things need to be handled quite carefully and delicately. So employees who are concerned about their health and safety may choose to raise issues in the first place with their line manager, and if the issue is still not resolved, raise a formal grievance or go through the employer's formal whistleblowing channels if they have these. So how to mitigate the risk of claims? There are a number of ways in which employers can, as set out on the slides, and just touching on a few of those. So implementing the suggested measures, such as carrying out a risk assessment and implementing or updating policies, training staff on health and safety duties and how to protect themselves and others, and ensure to apply disciplinary processes and sanctions where necessary. Update or implement a whistleblowing policy and train managers to deal with such issues and make staff aware of how to raise a complaint and how to access the correct channels of communication. Also, consider reasonable adjustments for vulnerable groups and those with disabilities, and seeking medical advice where required. So what health and safety issues could arise with people working from home? Quite a few. And employers could face various issues in this regard. So a number of things such as managing staff dealing with increased stress levels, possible burnout from the lack of division between home and office, ensuring that staff have safe and appropriate equipment, and being mindful of discrimination risks given continuing disparities in who takes more responsibility for childcare or caring responsibilities, and the likelihood that more women than men will work from home and do. So issues could arise if, for example, those in the office are favoured for work or are receiving better performance assessments and consequently pay rises or bonuses because they appear more present and managers have more visibility over their work. So how to mitigate the risks? Some examples: ensure home workers and in-office workers have equal access to all information, both in terms of internal resources and information about developments and changes within the business. Have regular catch-ups with home workers and ensure that virtual social activities are continued. And consider hosting all team meetings virtually, via Teams for instance, so that everyone is involved in the same way. Or consider if there might be a day when all members of the team can be present in the office together for meetings, although in this new time that might be more logistically challenging. Offer to carry out individual workstation assessments, and this can be done remotely now. And remind staff to take regular rest breaks as well as encouraging annual leave. Employers will also need to address further practical issues, such as tailoring standard employment contract clauses to encompass home working and taking appropriate measures to protect confidential information and personal data. I'll now hand back over to Richard to talk about the thorny issue of whether you can oblige your employees to take a test and get a vaccine. Thank you.
Thank you, Natasha. I'm going to start by dealing with testing. So I'm referring here to the lateral flow tests, which take 30 minutes or so to produce a result, and PCR tests, where samples are sent off to the laboratory for analysis. Helpfully, tests are specifically recommended by the government through the Department of Health. For reasons we will go on to explain, they are significantly less risky than having a policy of compulsory vaccination. Employees will have a duty to cooperate with the reasonable requests of the employer, and use of testing is now so widespread, it's hard to see how such a request may be unreasonable. You may have a risk assessment so as to ensure asking your employees to be tested on a regular basis is an appropriate action to take. In reality, we think there is little risk of a discrimination claim through asking all of your employees to submit to a testing regime. That having been said, there has been a suggestion recently that there may be a potential issue for those of the Muslim faith who during the month of Ramadan may not want to take the test if they're fasting. However, I've also seen a lot of material to suggest tests should not in fact be an issue, notwithstanding the obligation to fast. If you're to collate results following your employees' tests, do remember this is going to be special category data under the UK GDPR. There is helpful guidance on the ICO website, which you can refer to in this respect. If you're going to opt to require employees to take a test, you should consider introducing a workplace testing policy so that everyone knows and appreciates the regime. Finally, consultation with your employees will be vital. It will help to flush out any objections, if there are any, to you taking this step, and you may be able to deal with them before the issues become contentious. Moving on then to, can you make getting the vaccine compulsory, or no jab, no job, as it's been coined? In terms of the law, there is currently no legal requirement to have the vaccine. The government has for some time had the power in England and Wales to prevent, control or mitigate the spread of an infection, and under the Coronavirus Act of last year, this applies to Scotland too. However, at least currently, an employee cannot be required to undertake medical treatment, including having a vaccine. It's also worth bearing in mind the employee's duty in terms of health and safety in the workplace, as Natasha has already discussed. As we've seen, they have a duty so far as is reasonably practicable to safeguard the health and safety of employees at work. They should also cooperate so far as is necessary with their employers to enable them to comply with their health and safety duties. So what are the risks if you make vaccines compulsory? If an employee fails to abide by what you regard as a lawful and reasonable instruction, that could mean disciplinary proceedings and could mean ultimately dismissal. In such circumstances, an employer will be at risk of an unfair dismissal claim, especially if the employee has a good reason for saying it was not reasonable for them to be required to have the vaccine. I've given some examples on the slide, such as a fear of blood clotting, the employee being pregnant, or the employee having other personal health issues. If you seek to impose a requirement of mandatory vaccination, there is also a risk that an employee will resign for similar reasons and claim constructive dismissal. Right from the start of this debate, it was identified that there may be the risk of a religion and/or belief discrimination claim if, for example, an employee was an anti-vaxxer or their religion prevented them from taking a vaccine. There will also be the risk of a disability discrimination claim if an employee's medical condition is such that a vaccine could pose a risk to their health. And there are other risks too. The requirement to have a vaccine may be said to infringe an employee's human rights under Article 8 of the European Convention of Human Rights. And finally, and hopefully theoretically, there may also be cause for concern if at the end of the day we discover that there are in fact problems associated with some or all of the vaccines. Of course, we hope that will never happen, but if it does, that could pose a risk for an employer who had required an employee to take one. So what should employers do? What may be potentially very helpful would be government advice that in certain circumstances, making vaccination compulsory would be a reasonable step for an employer to take. That is something many commentators have been looking for and may come when the outcome of the review currently being conducted by Michael Gove at the Cabinet Office is published during the course of next month. In the meantime, we believe the best advice is to first encourage employees to take the vaccine through providing enough information so they can make an informed decision. Secondly, consult with your employees. That will be a good way of assessing what may be the problem areas for your staff. It may also give an opportunity to find out what you could do to accommodate any concerns they may have. For example, that may involve reallocating roles or changing the location of your employees when in the office so as to minimize the risks if you have some employees who have good reason not to be vaccinated. It is always a good idea to introduce such a policy carefully and to explain your intentions via clear internal communications. ACAS has suggested you might also find it helpful to introduce inducements to help encourage employees to take the vaccine. Examples they've given are paid time off for having the vaccine, full pay if off work because of a reaction to the vaccine, and this may be particularly helpful for your younger employees, and making clear that any time taken off because of a reaction will not count towards an employee's sick pay entitlement. Moving on then to sexual misconduct in the virtual workplace. In terms of managing your workforce in the future, assuming that would involve hybrid working, it's worth remembering where we got to with the sexual misconduct in the workplace debate before COVID. Ever since the start of Me Too at the end of 2017, sexual misconduct has been a real issue in workplaces up and down the country. Historic as well as recent claims have come forward, and employers and their advisors have had to be particularly careful in the way in which they've dealt with these issues. When last year employees effectively left the workplace to begin working remotely from home, some felt that will be an end to the issue, at any rate for the time being. However, that has not proved to be wholly correct. I've quoted on the slide a recent report from a charity, commissioned in fact by the Independent newspaper, which found that a quarter of women suffering sex harassment at work said the misconduct was exacerbated during lockdown. Around a half said that sex harassment was now taking place remotely. This issue is undoubtedly difficult for employers in circumstances where they may not be able to investigate face-to-face nor talk to their employees in person, but it is an issue nonetheless. If this is something that might potentially affect your place of work, and realistically the law of averages suggests that it might, we would suggest you can help to minimize your risks by making it expressly clear that standards of behavior will be the same wherever the place of work. If you're aware there may be issues, you can at least try to flush these out through catch-ups, remote or otherwise, with your employees. And where appropriate, any relevant sexual misconduct policies ought to be amended and updated to reflect the change in working arrangements that will be brought about by hybrid working. And finally, if you do receive a complaint, the important thing to do is to deal with it, and promptly. Ideally, of course, that would be in person, but if that is just not possible, then remotely. Being shown not to have moved promptly upon a complaint arising is very likely to count against you. Now we're moving to Emma Fowler.
Continuing this part one focus on UK-based employees, I'll speak initially about the immigration impact on sponsor licence holders, and then cover right-to-work checks that apply to all UK employers. Sponsor licence holders have certain duties and responsibilities, including record keeping and reporting. The authorising officer in the business is ultimately responsible for complying with these duties, but in practice, it may be another person in the team who becomes aware of a relevant situation. So it's good for anyone involved to have a general awareness of what changes are relevant from an immigration point of view. Sponsored workers, that is Tier 2, ICT or skilled worker visa holders, have a visa tied to their UK employment. They've no doubt spent much of the past year working from home where that has been possible, in line with the rest of the workforce. Normally, a change of work location for a sponsored worker would have to be reported to UK Visas and Immigration within 10 business days. However, UKVI issued guidance in the early stages of the pandemic, stating that temporary work from home due to COVID did not need to be reported. This sensibly avoided a situation where a report could have been required for the majority of sponsored workers. However, as we're moving forward out of mandatory work from home, it will be important for sponsor license holders to review the work patterns of their sponsored employees. Have sponsored employees changed their work patterns permanently so that they will continue to work from home on an ongoing basis, whether entirely or for a part of their time? If so, a permanent change will likely need to be reported to UKVI. This would no longer be covered by the guidance UKVI provided on temporary changes due to COVID. If possible, before a decision is made for a sponsored worker to work from home on a permanent basis, the employer should consider their justification of sponsoring an employee to get a visa for the UK only to work from home. Where permanent work from home is reported to UKVI, they may question the genuineness of the role and question why a UK work visa was required in the first place if an employee is to work remotely. UKVI guidance confirms that the role is not a genuine one if it's been created mainly so an applicant can obtain a visa for the UK. This could lead UKVI to question whether the employee could have remained in their home country and worked remotely from there without a UK visa. As a sponsor license holder, if sponsored workers will largely continue to work from home, a justification should be prepared in advance in case it is requested at a compliance audit. We believe that suitable reasons to have a sponsored worker in the UK, who's mainly working from home, could include the need to attend meetings in person in the UK relatively frequently enough that flying in and out would not be feasible. You may also think about any requirement to see UK clients face-to-face, or to be on UK time. There could be data or regulatory reasons that require a physical presence in the UK, even if not in the office. If some element of work from home continues for sponsored workers, do ensure that your policies and procedures are adequate to allow your continued monitoring of employees. You must know when sponsored workers are working or are on leave, and you must be able to present records of this to UKVI. You must have suitable processes in place to ensure that you would notice if a sponsored worker did not report as expected, either on their first day or at any point during their employment. This would surely be noticed by their line manager, but you need to establish reporting lines from them back to the relevant members of the team who are in a position to ensure reports are made to UKVI. I'll now briefly mention changes to the right to work check requirements. Even if you don't have a sponsor license, you should be carrying out right to work checks on all employees in the UK. So this piece applies to everybody, even those with only British staff. During the pandemic, there were temporary measures in place that allowed right to work checks to be carried out over video call. The end of these temporary measures was scheduled for 16th of May, but due to much lobbying from us and others, this date has been postponed to the 21st of June. From the 21st of June, video right to work checks will no longer be compliant. The good news is that you can carry out right to work checks on people with a visa who have a biometric residence permit using an online system. If you use this method, you're not required to meet in person. It's also possible to carry out right to work checks online for Europeans who hold status under the EU settlement scheme. The bad news is that not everyone has a status that can be checked online. A large group of people will have to be seen in person to carry out the check correctly, most notably British citizens. British citizens would usually present a British passport as their right to work, and this can't be checked online, so you'd need to see them in person with their passport. This feels like an unnecessary face-to-face meeting, but will unfortunately be required to comply with the right to work checks. There will be some situations where a new employee who requires a right to work check will be self-isolating. Obviously, in these cases, an in-person check will be impossible. Businesses will now need to consider their position in order to apply it consistently from the 21st of June. Whether to delay a correct right to work check and delay the work start date in line, which will no doubt be unpopular with the business and employee alike, or whether to allow employment to start during self-isolation, despite failing to complete a right to work check appropriately and the risks that entails. I'll now pass over to Jessica Clay from our regulatory team.
Thank you, Emma. Continuing the part 1 theme set out on this first slide are details of the topic I will be focusing on today, namely what you as an employer need to have in mind when you employ a regulated individual. First and foremost, my suggestion would be that any operational and business planning for hybrid working should take into account the regulatory obligations of any of your employees subject to individual regulatory oversight, even where your business is not subject to the same obligations. This will require systems, processes, and policies to be in place to enable the relevant employees to comply with their own regulatory obligations, wherever they are working from. The Regulator of Solicitors in England and Wales, the SRA, has issued some helpful guidance which specifically addresses this point in the extract which I've set out on the slide. So what are some of these regulatory obligations? Well, if we take any solicitors you might employ within your business, they have a duty to maintain their competence and professional knowledge and that of any individuals they manage, as well as to keep their understanding of legal, ethical, and regulatory obligations up to date. And it's not just solicitors with such obligations. Similar obligations would exist for other regulated professionals, such as accountants and architects. So, as an employer, the key question to ask yourself is, with a workforce operating both within and outside of the office, how can you help ensure compliance with these individuals' obligations? One observation from the lockdown period so far is that the opportunity for day-to-day on-the-job learning through informal office-based discussions, often coined casual collisions, is much reduced. Taking again the examples of a solicitor, accountant, or architect, if they are employed within your business, they will need to have access to training resources to promote their ongoing ethical and professional development, both in and outside of the office. Online hubs of resources and training modules would be really beneficial, as well as providing training record templates, which might help them to evidence the steps they have taken to maintain their competence. One key area of compliance for any such regulated individuals that you employ are considerations relating to AML compliance. Being equipped to obtain adequate client due diligence and ensuring compliance with AML obligations has certainly been put to the test by remote working. And while procedures and systems will no doubt have been developed and improved over the last year or so when onboarding clients remotely, formalising these processes as part of a hybrid working model should very much be seen as an opportunity to further enhance your clients' relevant procedures. To give a practical example, the Financial Conduct Authority has previously promoted the use of new technologies to support AML compliance, particularly in the area of CDD. An example includes promoting the use of biometric tools or online translation tools to help streamline the process for multi-jurisdictional businesses. The move to hybrid working should be seen as a fresh opportunity to introduce new technologies to better protect your business against financial crime and ensure regulatory compliance. An area of increased regulatory focus is workplace culture and the ethical values which run through a business. Take the recent news story involving a dozen or so junior employees at a well-known investment bank who stated that an average working week comprised 95 hours. The risk of employee burnout has received particular attention following the recent series of lockdowns, and the importance of employee well-being is certainly moving to the fore. And you might be thinking to yourself, but how relevant is all of this to my business? Well, while your business itself might not fall within a specific regulator's remit, we are seeing evidence of regulated employees referencing an oppressive and a bullying working environment and a toxic work culture when facing their own disciplinary proceedings. In my view, something that will therefore need to feature more in future business planning is how to promote and maintain a positive workplace culture and embed ethical values and behaviours within the hybrid working model. clear online communication channels, and robust and cohesive messaging as to your business's values, and an unwavering promoting of an inclusive and supportive workplace should feature in future business planning, as should consideration of employee well-being. It is clear from much of the work we do that a positive workplace culture is becoming a business essential. It is widely seen to promote innovation within teams, to enhance a business's reputation by creating a positive public perception, to help with the attraction and retention of highly qualified talent, and to reduce the risk of misconduct from employees, perhaps because there is less of a blame culture and they feel more supported and more able to speak up when they need help or guidance. Finally, another topic of importance for businesses to be aware of is an increased interest by regulators in the private lives of those they regulate. We have certainly seen that hybrid working can bring with it an increased risk of a blurring between what is private and what is professional. The need to maintain professional standards at all times when outside of the office, and for regulated professionals to have in mind that conduct in their private lives risks being subject to regulatory scrutiny, should form a key part of any future messaging around hybrid working that you seek to impart to those you employ. Any possible conduct issues of this nature may prove much more difficult to identify and monitor in a hybrid working environment, as the individuals engaging in such conduct can more easily hide behind, for example, online messaging and the fact that they are largely working remotely and virtually. In my view, tackling such issues at source is of great importance. This can be achieved by encouraging internal reporting systems, developing clear communication channels as to behaviour that will not be tolerated, and delivering training sessions tailored to a hybrid world of working. Such steps, in my view, will go a long way in helping to build and maintain the positive culture of your business. I'll now hand back to Richard.
Thank you, Jessica. So, what are the headline issues employers need to be aware of in relation to remote working outside the UK? This is a question that many of you have asked about. It's likely to rise in practice. Employees have plainly cottoned on to the fact that if they can work remotely at home, they could do so pretty effectively anywhere in the world, and not just here in the UK. But there are a number of important issues that you will need to be aware of. First is the fact that local employment law may trump UK employment law in terms of various entitlements, such as annual leave, sick pay, and dismissal rights. Before you agree to any proposal that an employee works abroad, that is something you must check. Secondly, it's terribly easy to informally agree to such an arrangement, but we would suggest it is preferable to document any agreement in writing. You may want to include, for example, and if applicable, any appropriate timescales where you want the arrangement to be for a limited period of time. You could then realise both sides' expectations and evidence any such arrangements should there come to be a dispute in the future. Thirdly, you should check to see whether there are any local company law obligations, which may require you to set up a local office in order to operate in the relevant jurisdiction. You should also think about how you may be insured should the employee meet with an accident or fall ill while they're based abroad. Then there are the tax implications. You will need to know what are going to be the tax arrangements once the employee begins to be based away from the UK. You will need to know whether you continue to pay salary via PAYE and continue to deduct national insurance contributions, or whether there are other taxation arrangements in the country in which the employee will be based. This could be complicated and advice must be taken. Then there are the practical issues, such as the hours you're expecting the employee to operate. Will they be local or based on UK time? That could be important in terms of customer service and internal meetings. It will be as well to get that agreed before the employee starts working from abroad. Finally, there are the potential immigration and data protection considerations, and these will be dealt with by Emma and by Andy. So over to Emma for managing absences for UK visa holders.
Continuing this part 2, I'll focus on UK employees with a UK work visa. I've seen that many sponsored workers with ties overseas have taken the opportunity to work remotely from a family home, for example. However, I expect most UK visa holders intend to return to the UK when things return to normal. With that in mind, I'll quickly address some frequently asked questions about extended absences from the UK for visa holders. Can visa holders who have been outside the UK for a long time simply come back now if they wish? In most cases, yes, this is possible. If their absence was less than 2 years, their current permission shouldn't be affected. Does a long absence impact a future extension application? For work-sponsored visas, no, an extension application shouldn't be impacted. Will a long absence from the UK impact a future application for indefinite leave to remain or permanent residence? It could. UKVI has confirmed that absences due to COVID could be disregarded from the travel limits in an indefinite leave to remain application. However, we haven't yet been able to test this position. It's not clear how generously this exemption of COVID absences will be applied. It seems unlikely to me that UKVI will be happy to disregard 9 months working outside the UK, for example, at the employee's own choosing. However, we would expect UKVI to disregard absences outside the applicant's control. So, for example, time spent abroad to care for sick family, or time stuck abroad due to travel bans. And evidence of all of these reasons should be retained. A recent change to the immigration rules is particularly relevant and positive in this situation, where a sponsored worker may not be eligible for indefinite leave to remain due to high absences. Until last year, sponsorship under what was Tier 2 General and is now skilled worker was capped at 6 years in total. That meant that people had to qualify and apply for indefinite leave to remain between years 5 and 6, or else leave the UK after 6 years. A long absence in that case could therefore ruin the chances of obtaining indefinite leave to remain and mean that the UK employment had to end. Now, fortunately, time under skilled worker is not capped. So in the worst case scenario, if you do have employees who have very high absences, too high to qualify for indefinite leave to remain, they could instead apply for an extension. There would be a cost impact with this decision though, as further years of skill charge of potentially £1,000 a year and health surcharge at around £600 a year would apply, which would not have applied to an indefinite leave to remain application and may therefore not have been budgeted for. I'll now hand over to Andrew in Corporate and Commercial, who will start part 3.
Thank you, Emma. I'll now take you all on to part 3 of our webinar, which deals with issues arising from hiring freelancers and employees based abroad. And I will initially focus on data protection issues. I'm a corporate and commercial lawyer, and I often work with entrepreneurs who run fast-growing businesses in the technology sector. And I suspect it will come as no surprise to you that many of my tech clients hire freelancers to carry out work for their businesses, and they're often based in different jurisdictions. It might be software developers who are based in India or Eastern Europe, perhaps the nomadic freelancer who's based in different jurisdictions at different parts of the year. The pandemic has demonstrated that remote hybrid working is not detrimental to productivity. And if talent can continue to be sourced from abroad at a cheaper rate than the price payable for comparable expertise in the UK, it seems that hiring freelancers based abroad will continue to be a rising trend. Now, there are many commercial issues I could touch on in relation to this topic, but as I said earlier, I'm going to focus on data protection because hiring a freelancer based abroad potentially increases the risks of materially breaching the UK GDPR if something goes wrong and that freelancer suffers a data breach and loses your organization's personal data. I'm going to focus on 2 main issues of concern, and they're set out on this slide. Can you lawfully transfer personal data to the jurisdiction where your freelancer is based? And do you need to put in place a contract to govern the data processing to be carried out by the freelancer? I'll deal with each main issue in turn. However, before I do so, I should briefly mention that the issues I'm covering today do not apply to your employees who are based outside of the UK. In an employment relationship, whilst personal data is transferred outside of the UK, it is not transferred outside of your organisation, and so it remains subject to the UK GDPR when processed by those employees who are based overseas. You therefore needn't worry about the mechanisms I will discuss today if your primary concern is about employees who are based abroad processing company data. However, you should, of course, ensure that those employees based overseas are exercising the same degree of care and attention over personal data as they would do if they were sitting in the office in the UK. I'll turn back now to the freelancer position, which unfortunately is a little bit trickier. The first hurdle to jump being the lawful transfer of personal data overseas. Now, in order to lawfully transfer personal data outside of this jurisdiction, you'll need to rely on at least one of three permissible mechanisms set out in the UK GDPR. Your first consideration should be ascertaining whether you're transferring the data to a freelancer based in a country which is deemed to have adequate data protection laws in place in accordance with the UK adequacy regulations, and I'll elaborate on that shortly. If the jurisdiction where your freelancer is based is not covered by the adequacy regulations, then you should ideally put in place a safeguard under the UK GDPR to protect the data that is going to be transferred. And I'll discuss an appropriate safeguard under the legislation in a moment. Finally, if you're not relying on either an adequacy decision or a safeguard, you will need to rely on a derogation under the UK GDPR in order to transfer that personal data to the freelancer based abroad. And essentially, derogations are a list of exceptions to what can be considered a general prohibition on transferring personal data outside of the UK. And again, I'll elaborate on that shortly. Hopefully, you can now see a list of countries to which personal data can be transferred lawfully in accordance with the adequacy regulations. If your freelancer is based in one of these jurisdictions, you're not going to need to worry about either safeguards or derogations. As you can see, we're talking about EU member states, we're talking about European Free Trade Association states, Iceland, Norway, Liechtenstein. We're also talking about states which are already covered by historic EU adequacy decisions. There are 11 countries that are listed there. But what if your freelancer isn't based in a country with an adequacy decision? If that's the case, you'll need to put in place a UK GDPR approved safeguard in respect of the data that's going to be transferred. And in this case, entering into a contract with the freelancer called the Standard Contractual Clauses, the SCCs, is probably going to be your solution. So what are the SCCs? Well, they're a set of model contracts that have been created by the European Commission, which contractually bind the freelancer to processing your personal data in accordance with UK GDPR standards, even though that freelancer is based in a jurisdiction which doesn't apply those same standards in its national laws. And entering into the SCCs means that data can be transferred overseas to the freelancer lawfully, provided that the SCCs are not amended in any material way from the template form in which they are provided to you. You need to make sure that you enter into the correct set of SCCs with your freelancer, based on whether the freelancer is a data processor or a data controller in accordance with the UK GDPR. And I will touch on the difference between those two positions shortly. Finally, it's worth flagging that the legal landscape in respect of the SCCs is likely to change later this year as a result of Brexit. Rather than continuing to use the European Commission templates that are still lawful to use now, it's been proposed that new UK SCCs are likely to come into force to replace them. So essentially, watch this space. Now, if you're not relying on either an adequacy decision or the SCCs to lawfully transfer personal data to that freelancer based overseas, your last hope is going to be relying on a derogation. In practice, it actually seems rather unlikely that any of the derogations will be able to apply in respect of repetitive transfer of data to a freelancer based overseas in a typical commercial relationship. As a result of that, even though I've flagged the derogations on this slide, I'm not going to go into any of them in any kind of detail, but at least they're there so you know that they're available as a last ditch, get out of jail free card, so to speak. Okay, you've jumped the first hurdle. You've ascertained a lawful means of transferring the personal data to the freelancer based abroad. Your next consideration should be whether you need to enter into a specific data processing contract with them. And this would be in addition to the SCCs if you needed to use them as your lawful basis of transferring the data in the first place. The key consideration is whether your freelancer is a data controller or a data processor under the GDPR. Fortunately, the easy part of this process is that your organization will always be a data controller in respect of the data that it sends to the freelancer. The manner in which the freelancer processes your organization's data will determine whether they are a processor or a controller. Now, the freelancer will be a data controller if he or she, rather than your organization, exercises overall control over the purposes and means of processing the data once they get their hands on it. If, for example, you're providing your freelancer with details of your customers for the purposes of that freelancer conducting a customer satisfaction survey with them, and if that freelancer has control over the form of the interview, which customers they ask and how to present the results, it's very likely that they'll be considered to be acting as a data controller. Now, there are no formal data processing contracts required when data is transferred from one data controller to another. But the freelancer should, in the role of a data controller, have a privacy notice which sets out exactly how they process personal data, and the personal data they receive should only be processed in accordance with that document. Remember to ask if they have one in place, or better yet, include a provision in your consultancy agreement binding the freelancer to data processing in accordance with their GDPR compliant privacy notice. Moving on to the processor scenario. On balance, freelancers are much more likely to be data processors than data controllers. And this is because data processors do not process personal data for their own purposes, and they typically have very little or no control over the processing. Rather, they are only processing personal data on the instructions of the data controller. By way of example, if you provide personal data to a website developer based overseas, and that personal data is solely to be displayed on the website that they're developing, your developer is likely to be considered a data processor. Under the UK GDPR, data processors must enter into a legally binding contract which contains certain provisions specified within the legislation. This contract is commonly referred to as a data processing addendum, a DPA. That's because you'll have a main agreement in place between the parties, in this case, a consultancy agreement, and the DPA will slot in as a schedule or addendum to that main agreement to deal with the data protection elements. Now, the slide in front of you contains a high-level overview of the required content of a DPA in accordance with the UK GDPR. We don't have time now to go into detail and discuss all of those requirements. However, if you need a DPA in place, don't treat it as an afterthought to the contractual negotiation process. Ensure that you put a DPA in place if necessary, and do ensure that it covers all of the requirements under the UK GDPR. That brings me to the end of a very high level and whistle-stop tour of data protection concerns when hiring freelancers based abroad. I'll pass back over now to Emma, who will discuss some final concerns from an immigration perspective.
I'm often asked if it's possible to offer a UK contract to somebody overseas who doesn't have a right to work in the UK. Please do keep in mind the various key considerations that Richard mentioned earlier. But from a UK immigration point of view, this is fine, as long as the worker remains outside the UK. Despite a UK contract, UK immigration restrictions and right to work requirements aren't applicable if the worker is physically overseas. However, you should ensure that the worker is permitted to carry out the work you're offering in the location that they're working. Often the employee will be a national of the country they're in, which is fine. But if you have someone working elsewhere, you may need to consider local, i.e. overseas immigration and work permission requirements. I'll pass now briefly back to Richard to close.
Thank you, Emma, and thank you everybody for listening. We've received lots of questions, as I said at the beginning, and we have tried to give answers in all of our presentations. But if there are further questions that you have, please be in touch with us. You could do so via email, via telephone call, And as I say, via the QR code, which may be the easiest way for you to get in touch, which Melanie has just put on the slide. We'll also be sending out the recording. And all that remains for me to do is to say thank you so much for attending in such numbers, and we very much hope to be able to see you soon. Bye-bye.